Uh, tonight's is conservatorships and alternatives. Um, it was a four-part series on securing our financial future for our loved ones. I am Alyssa DeFilippo, Program Manager for Connections California. It's a statewide online resource and information hub for transition to adulthood and adult services. This evening's presenter, as it has been for the last three of this series, is Ellen Cookman of Cookman Law. And Ellen started Cookman Law in 2015 to help families of all shapes and sizes plan for the future and utilize available resources. Ellen is a certified specialist in estate planning, trust and probate law from the California State Bar Board of Legal Specialization. As we all know, our families need parenting when we're gone, and Cookman Law helps families put together a team of professionals and family members to provide additional financial and care management and support. They also offer trust administration services when needed. So I want to thank Ellen for being here. I thank Beatriz, our Spanish interpreter, for being here. And I also thank Moira Alberton, who is from a sister agency in San Diego called Exceptional Family Resource Center. And she is here this evening to help facilitate questions and also drop some local resources in for folks who are joining us from the San Diego area this evening. All right, I'm going to stop sharing. I thank everyone for being with us again. And Ellen, it is your turn.
All right. Well, let me share my screen. Thank you so much for inviting me 4 times in a row. This is great. And this is our last one. So, but I think I will be back at the beginning of May. So that'll be really fun.
Oh,
Um,
that's right. I'm sorry, I forgot to say that. I was going to, that Ellen will be back to talk about siblings and how they may or may not figure into the financial planning. So the calendar will be ready on January 15th. So watch for that. Thanks for that reminder, Ellen.
oh, awesome. Oh, of course, of
And the
course.
screen looks great.
Oh, okay, great. Okay, so yeah, today we're going to be talking about conservatorships and also alternatives if you don't choose to conserve your child. And this is what Alyssa has so kindly shared. I do have a 12-year-old with high functioning autism, and I have a 10-year-old who's neurotypical. Um, and I've been practicing in this field since, boy, 2008. And I've done conservatorships for quite a while. And right now I don't do them because, as I've mentioned in my past presentations, I just don't like going to court. So right now our office is not doing conservatorships, but I did them for quite a while. And I said, hey, I'd be happy to share the information that I have. I can also share, other people who in this area who do conservatorships. So really, what we're looking at here is decision making, right? How do we help our loved ones with limited capacity? How do we help them to make good decisions? Do we take over their decision making, which we call surrogate decision making, where we make the decisions instead of them? Or do they delegate to us the ability to make a decision? So they voluntarily say, hey, I want my mom to be able to sign checks at the bank. I want my mom to be able to talk to the utility companies for me. Do we share the decision making with them? Or do we set up, it could be and or, right? Because you may use all of these in different situations. There's no one right answer, okay? But I think a lot of these you might try out with your kids and see what happens. Now, this comes up when your child turns 18. Before your child is 18, they are a minor. And so you get to make decisions for them. Now, I've heard recently that as your kid gets older into their teen years, sometimes doctors don't want you in the room when they're giving your child an exam. Sometimes schools don't want you as part of the IEPs, even if your child is not yet 18. So there are some tricky things that are going on, but mostly we're talking about age 18. That in California is when a child becomes an adult, and now all of a sudden they can make their own decisions, even if they're not capable of it, or even if their decisions are not good. All right, so that's where we're really looking at. So first, I want to talk about kind of the biggie. Okay, I'm going to go through, information about conservatorships, and then I can take some questions. Okay, so what are conservatorships? It's as we mentioned, surrogate decision making, where the government, you go through a whole court process. You always have to go through court when you're doing a conservatorship. It's unlike a revocable trust or a special needs trust or other types of estate planning where you don't go through court. You just do everything through paperwork and agreements. When you're conserving somebody, you're basically taking away their right to make their own decision, and you're imposing your own decision making on it. Even if you're a parent, you have to go through this when they turn 18. I bet 98% of parents are perfectly good conservators for their kids, but it's those 2% of parents that may not do the right thing for their kids that make us all go through this whole process, even though we're parents. Okay, so this is required if you choose to conserve a child. All right, so when we're looking at conservatorships, there's really two areas that we need to consider. There's conserving the person. So that means like their ability to do activities of daily living, where they live. Do they do education? Which doctors do they see? So things kind of related to their person, related to their body, related to the stuff that they do every day. And then there's the conservatorship of the estate. So that's related to their money. All right. Now, typically, well, I'll talk about that in a second, but just to let you know, really, those are the two fields that we look at when we're looking at a conservatorship. Now, who gets to act as conservator? Typically, for a child with developmental disabilities, it would be a family member or a friend. If there's no individuals who want to act as conservator, then the public guardian of that county can step in and be conservator. But they have a very big caseload. So I usually recommend find a person if you can. And then there's also professionals. So there are some examples, some private professional fiduciaries who act as conservator. Not all of them do, but some do. I believe Good Shepherd Fund acts as a conservator of the person and the estate. So you can look around. You can find some that do act as conservator. So within the umbrella of conservatorships, there's three types. All right. There's the regular conservatorship, which is basically for somebody who is elderly, maybe they have dementia, they need everything. They need to be taken care of really for the rest of their lifetime. All right. Honestly, Britney Spears, that was a regular conservatorship, interestingly enough. And that brought a lot of attention and light to the conservatorship process and some of the abuses. Then we have the limited conservatorship. So that is for individuals with developmental disabilities. Okay, so Down syndrome, autism, cerebral palsy, things that you're kind of born with or developed genetically. And you need to be a member of the regional center to get a limited conservatorship. The final one is called an LPS conservatorship, and that's for people with grave mental health challenges. Typically, we also call it a 5150 conservatorship because typically they impose a conservatorship when you're in a lockdown, okay? When you've had a crisis and you're hospitalized. Then, and the only person who can institute an LPS conservatorship is the public guardian. Okay, so a parent cannot immediately go for a conservatorship over somebody with mental health challenges. This, I think, is a huge hole in our system. All right. Now, if you have somebody with comorbidities, let's say they have autism and they have mental health challenges, you can get them conserved under a limited conservatorship because of the autism diagnosis. But if they only have bipolar, even if they're making horrible decisions, even if they've been hospitalized 3 times in the last year, it is still very, very hard to impose a conservatorship over them. I'm not going to opine on why or the history of it, but just to let you know, I'm not talking tonight about LPS conservatorships or regular conservatorships. I'm only talking about limited conservatorships. I believe that's the majority of the attendees here are interested in that. Okay, so the reason why it's called a limited conservatorship is that the presumption is we want people, we want our kids with developmental disabilities to be as independent as possible. And so we pick and choose which powers we want to impose on those kids. It's limited to the powers that we ask for. And there's 7 powers that we can request. Okay, so the power over where they live, the power to access their confidential records, power to enter into contracts, the power to get married, the power to give medical consent, the power to choose their social and sexual relationships, and decisions over education. Now, let me just mention, we're in Santa Clara County. In Santa Clara County, unlike other counties, points 4 and 6 are hardly ever granted. You know, consent to marriage and social and sexual relationships. Courts just don't want to touch that, and the public guardian digs their heels in. Even if there's a real record, you'd really have to fight for that. So typically, in Santa Clara County, you ask for 5 of the 7 powers. All right, so what does this procedure look like? You know, if you're thinking about this, what do you do? So first, there's a lot of paperwork that you need to fill out, and typically you would work with an attorney, but you don't have to. I believe Parents Helping Parents actually has a self-help program, and Alyssa, you can correct me if I'm wrong later on. But you know, you can go through that, but the paperwork I think is pretty complicated. It's easy to miss some boxes that get checked. So a lot of times you would work with an attorney to make sure you get it right. All right. There's other things that you need to fill out, like you need to get a doctor to fill out a capacity declaration to talk about the capacity of your child. You need to fill out confidential supplemental information screening, basically to say, hey, I don't owe my child any money. They don't owe me any money. I'm not a convicted felon. You know, I'm the right choice for this. And that is not public record. So there's certain things that get filed confidentially, okay, are not available to the public. All right, so once you file it, you get a notice of what the hearing date will be, and then you need to submit that to family members to the second generation, just in case they want to step forward and say, hey, I want to be conservator instead, and they can attend the hearing, but that's very, very unusual for that to happen. You also need to serve the child themselves a copy of the notice of hearing and the petition itself. And now you might say, but my child has no capacity. Maybe she's bedridden, maybe she's unconscious. You just put the citation right next to her bed and you're done, okay? Now, the child is assigned their own attorney, or in Santa Clara County, they're assigned the public defender. And that attorney will interview your child. Now you might say, well, that, you know, what if my child doesn't understand the questions, or maybe they just say yes to every question. The public defender has done this a lot. So they would kind of recognize, and they can also talk to you, and you can kind of prep them like, hey, these are the things that you might encounter, and they appreciate that. Okay, then the regional center needs to write a report. Okay, that's why you need to be a member of the regional center in order to apply for a limited conservatorship, because they're looking for this report from the regional center. Even if the regional center hasn't provided a whole ton of supports to your child, you still need it. Then a court investigator. So then the judge is sending their own investigator out to interview you as the parent, to interview the child, and maybe neighbors or friends, whoever you might put on the petition, to make sure that you're the right choice. So they're really going through a vetting process. They're making sure that you are the right person for this job. And then finally, there's a hearing. Nowadays, you can attend online, which is really nice. You used to have to go down to the courtroom, and it was especially hard when you have a kiddo who has a short attention span or doesn't want to be there. So now you can just be on camera. And typically, in my in my experience, typically it's granted, but I would only take cases where I know it would be granted. Okay. Okay, now you can get a fee waiver. So if your child is receiving public benefits or they qualify as low income, they can waive the fee for getting a conservatorship. Now, what happens once it's granted? Okay, so when it's granted, there's an order, and then there's something called letters of conservatorship. That's like the one-page document that you actually carry around with you. And when you go to the doctor, you give the doctor a copy of the letters of conservatorship, and it says, I, Jane Smith, am, conservator for Christopher Smith. And so they keep that in their records, and now they can talk to the mom, right? And unless it automatic, well, I don't want to say automatically, but you don't have to reapply. Okay. At least in San Mateo County, every 2 years, they make you fill out some paperwork stating whether there's been any updates or anything. They haven't been needing to do that in Santa Clara County. So it's basically business as usual unless and until they ask you for some information. And if something changes, like if your child moves, for example, you're supposed to report that to them. So it's really on you, on the conservator, to report any changes. Okay, so I get so many calls from families where they're like, do we need a conservatorship? What are the pros and cons? So one nice thing about a conservatorship is it really does protect a child from financial predators. Any contract that they enter, if you have the power over contracts, is void. So let's say they sign up for a credit card and they buy a $50,000 round the world cruise, which they're not going to go on, then that is void. Okay, as opposed to being judgment proof. If you don't have a conservatorship, you say, hey, my kid has no money. You obtained this over fraud, so sue them, right? But it could affect your child's credit if you care about that. It's also a way to protect them from if they really have poor decision-making skills, especially if they're out in the community and they're vulnerable, or you don't like their decision-making. Also, if they don't have the capacity to make decisions, then it can be very important to get a conservatorship. I've had a lot of parents, since they've been making so many decisions for their kids, they just don't feel comfortable having their kid out in society able to make their own decisions. Now, I do want to emphasize that having a conservatorship does not protect you from your kid making bad decisions, right? I mean, but it can protect them from some of the consequences, like I explained. Getting that credit card, it protects them from the consequences of obtaining a bad credit score. Also, if they need to, get a big surgery and they don't want the surgery, then you can, petition for a conservatorship over medical decisions and kind of force them to get the surgery that they really need. Okay, so what are the drawbacks? Well, it's very expensive. Well, not very, but it's expensive. You have to, whenever you're going to court, they make you pay for filing fees. You have to go through court. It takes a long time. Usually it takes like 3 to 6 months at least. And really you're taking away that person's rights. And that can be seen as not empowering them. And when you're not empowering somebody and you're not expecting them and teaching them to make better decisions, that can lead more to abuses. And then also it's just not available for everybody. If your child does not qualify or is not a member of the regional center, they can't get a conservatorship. Okay, so I have a few questions that are typically asked. We did talk about, what is a conservatorship? So the person applying for the conservatorship is called the conservator, and the disabled child is called the conservatee. All right, so that's kind of the terminology. So these are the decisions that they can make, right? We talked about them: healthcare, education. How long does the process take? At least 3 months. In Santa Clara County, I'd be looking at like 6 months. So I'd say if your child is approaching the age 18, I'd say probably at age 17 and a half, you can start this process. Then the hearing date can be on their 18th birthday. Happy birthday, you're conserved, right? And then there's filing fees, there's some other fees. You can terminate a conservatorship if you want, okay? And also you can add somebody to the conservatorship. Now, and some parents do this. Parents will start out as the conservators, and then as maybe they have a neurotypical child, and as that child gets older, they say, hey, I'm willing to be the conservator for when the parents are gone. Let's make that transition a little bit smoother. And they name their child as co-conservator with them. Now, the child has to go through this entire process because the child has to be vetted. You remember like all those steps, right? You can't just say, oh, now I'm bringing on my child. No, the child has to make sure that, you don't have to get a new capacity declaration or certain things, but the child does have to fill out that confidential supplemental information form. The child will be interviewed. All right. So there is a process, but then you can have 2 or 3 co-conservators. I once had a case where it was a family of, parents and then 4 kids, and one of the kids was disabled, and they all lived together. Culturally, that was acceptable in their family. So 4 adults, one disabled, and the parents and the 3 neurotypical children all became co-conservators, 5 people in one family. I don't necessarily recommend that because if something needs to be signed, you need to get all 5 signatures. But since all of them lived together anyways, it was doable. Okay, so I'm going to pause there and invite Alyssa to come back on. And Alyssa, you can maybe, if there's questions about conservatorships, we can look at those.
Hi.
Oh,
We
hi,
have quite
Moira.
a few questions actually. So
Okay.
I've been answering a couple that I'm confident about, but
Mhm.
the first question is, do you need an attorney for all these types of decision making? So going back to
So,
your very first, where there's all the different kinds.
right. Okay. So the answer is no. You don't need an attorney. I think the conservatorship is the most complicated part, and I usually recommend using an attorney. I've had clients who tried to do it on their own. They got stuck, and then they came and hired me. And basically, we started over. But if you're very short on funds and you can't afford to hire an attorney, you can go through the self-help process. And I've found that courts are very lenient with that. I mean, if you check something wrong, then you will have to go and fix it. Like they don't overlook those things, but they do recognize that some people represent themselves.
Agreed.
For the other things, by the way, for the delegated decision making and the supported decision making, no attorney is needed.
But for the advanced healthcare directive and the durable power of attorney, though, you would probably need legal or no?
Not necessarily. They have those forms online. They're statutory forms. Now, when I'm doing somebody's estate plan, we draft, detailed durable powers of attorney and advanced healthcare directives. But if you have a child who has, some capacity, but they don't have a lot of assets, they just need a simple form. There are forms, California statutory forms available online that you can have your child sign in front of a notary. Now, if your child is under conservatorship, you can't get those forms. So it's really one or the other.
Thank you. That's a really important point. One or the other, not both.
Exactly. That's right.
Another attendee tonight has a child with multiple diagnoses, Fragile X and autism, and they're asking about having just a regular conservatorship, not a limited. So again, I heard you say limited, you have to have that regional center identification.
Right.
And so the question is, can you tease out the difference between limited conservatorship, which kind of sounds like less, versus conservatorship typically
Yeah.
associated with elderly clients?
Well, if you have somebody who has a developmental disability diagnosis, they want you to do a limited conservatorship. They'll ask you, why are you doing a regular conservatorship? Now, if you have a child who just has, severe physical health challenges or, some other challenge, then you can go for the regular. But it's not like the limited is inferior in any way. It's just a different name. And they call it because ideally we want to limit the parent's ability to impose themselves on the kid because we want the kid to be as independent as possible. So that's really the concept behind it. In practice, it's a very similar process. There's slightly different documentation that's used, but it's fairly similar.
Next one's similar. What about this is if your child has these diagnoses, but they're not a client of the regional center.
You probably need to get them to be a client of the regional center.
And I've actually seen it in San Diego where the court will hold you in a state of temporary guardianship until they can have the regional center do their evaluation.
There you go. Yeah.
Fun fact from San Diego. Okay.
There you go. There you go. Yeah.
Does this work? So I'm thinking that this is a reference to when you mentioned an individual with comorbidity. So does this work for a 45-year-old dual diagnosis confrontational person?
Oh, well, the challenge with somebody who's confrontational is that they might object to the conservatorship. And then you might be off to the races. Because if you have someone who doesn't want to be conserved, then remember you have an attorney or the public defender who's appointed to really represent their wishes. And if they say, no, I'm fine, I don't want to be conserved, then that's going to be considered by the court. And the court's going to look to see, do we really want to impose this against their will? In my practice, I never took those. I was a litigation attorney for 4 long, horrible years. And so I don't like fights, so I wouldn't take those cases on. I can tell you, I had one case where we applied for the 5 powers. And at the hearing, the public defender came up to me and said, hey, listen, this boy, he wants to make his own education decisions. He disagrees with what his parents want him to do with education. And so I recommend that we remove the power to make education decisions. And I talked to the parents, they were fine. So we just basically crossed that out of the order. And so they were granted 4. So you can, negotiate these things, but if you have somebody who's really oppositional, it can be very difficult to get that passed.
Yeah. Next question. Can you get a limited conservatorship if your child, oh, sorry, that one we just answered. Is there a set amount for the fee or does it vary?
So the court fee for the filing the application, I believe, is about $450. However much the attorney charges is really up to the attorney. So, I guess you can shop around if you're really concerned about fees. But do keep in mind, there's a lot of work involved. Whenever you're going through court, a lot of things can go wrong. So we love assuming, oh, it's going to be smooth sailing, but not necessarily. So I really can't speak to what an attorney might charge.
Okay, so this is one about limited conservatorship. Can only one parent apply for limited conservatorship if the other parent has a sink or swim view for the child transitioning to adulthood? So what if the parents don't agree?
And unfortunately, this is very common, as I'm sure we've all seen. The divorce rate is very high among the special needs community because of this. I think because parents have a different opinion of how to approach this. The parent who wants to impose the conservatorship can go through the process, but the other parent is entitled to a copy of the paperwork of the petition and the hearing, and they can come back and say, oh, wait, hold on, I want to be appointed co-conservator, or they can come back and say, my kid doesn't need to be conserved. And then again, you're off to the races. So usually this is something you'll want to sort out before you go to court. It's very sad. I have a personal friend whose son has pretty severe autism and he really needs to be conserved. But she and her ex-husband can't get on the same page about, conserving him, and it hasn't been done. So it's very unfortunate, but, the other parent does get a say in this.
I'm just going to say that perhaps we may want to go back to the presentation because I know we have a bit more left and the questions are piling up as they tend to do.
Oh, okay, sure.
So I don't want to miss finishing the presentation.
Okay, sounds good. Sounds good. Okay.
Thanks.
So yeah, thank you, both of you. Okay, so let's talk a bit about supported decision making. All right. So really, there was the Britney Spears case. There were a few other cases of limited conservatorships gone wrong. All right, where people kind of abused the ability to conserve somebody and, somebody with developmental disabilities against their will. And so we started looking around, and this has actually been happening for a while, saying, what are some alternatives to this? What if we don't want to conserve our child, And so supported decision-making has become a lot more popular in the 2010s, 2020s. And last year, California passed a supported decision-making statute. So now it's official. So I want to talk about what it is, when might it apply, how do you do this with a conservatorship or without, so we can talk about all of that. All right, so what is supported decision-making? I want to give an example. All right, so when I was in law school, my dad was the dean of a law school, of Temple Law School on the East Coast. And so he knows everything about law schools. He's, practicing attorney. And so I asked him a lot of questions about law school. Okay. He was my supporter. He helped me through that challenging process. All right. Now, keep in mind, I didn't ask him for dating advice. I mean, really nice guy. He's great. I appreciate him and my stepmom. They're all good. But, so there's certain areas that I felt like I need help in, and I want to pull in these different people into my life who I respect and admire. And they're kind of like my mentors. And I put a group of support around me. That's the concept of supported decision-making. You have an individual who wants to get help with their decision-making skills to make better decisions. Okay, so the disabled person themselves, the decider, they get to make the decisions, but they get advice from other people who can go with them to the doctor's appointments, help them to read contracts, but ultimately it's the decider, it's the disabled person themselves who has the legal ability to make their own decisions. Okay, so it's considered a less restrictive alternative to conservatorship. And let me actually mention, when you're applying for a conservatorship nowadays, they ask you, for a long time they've asked, why isn't an advanced healthcare directive and durable power of attorney, why isn't that sufficient as a least restrictive alternative, right? Because especially in the developmental disability community, we want our kids to be as independent as possible. At least, theoretically we do. Now they've added another question, why isn't supported decision-making a viable alternative for them? So this is something that we should all at least think through. Even if it's not the right choice for your kid, it's something really to understand. Okay, so here's a comic that I really like, all right? So it's kind of showing the difference between the two. So first we have, the person on the left who says, but I want to live here with my friends and stay here. And then you have the guardian. In other states, we call it guardian. Here we call it conservator. All right. So you have the conservator saying, sorry, I don't think that's what's best for you. And I'm your conservator and you will live where I want you to live. All right. So that can be the dynamic of a conservator and conservatee. The conservator is making the decisions, even if the conservatee disagrees. Okay. So supported decision-making, this is more what it's supposed to look like. The not conservatee, the decider says to the supporter, hey, can you help me figure out how to buy a house and live with my friends? And then the supporter says, sure, I'll help you do it. Let's look to see what you can afford. Okay, so you see the difference in the dynamic. The decider is really making the decisions, but they're getting a lot of help for it. All right, so why do we care? Why do we even want this in the first place? So studies have shown that those who are able to make their own decisions, that self-determination just has a better life outcome, okay? That it's better for people's mental health, physical health, to feel like they can make decisions on their own. It helps people to look around and say, okay, who are my supporters? Who do I pull in? So many times we do this subconsciously, but when you do it purposely, it's very powerful, okay? And we're letting disabled people really retain their legal capacity and their wishes are respected. So, they feel like they fit in more in society. They can make their own decisions, okay? Now you can say, within this certain framework, but, they've found that people who are not conserved are less likely to be abused in group homes, for example, because they've learned, better coping skills. They've learned how to stand up for themselves. So that's really the theory. Whether it's 100% right, I can't address that, but this is what, what the theory is behind it. Okay, so how do you do this? So you can do this verbally, but usually it's in a written agreement. All right. And California does not have their own written agreement yet, which is too bad. But I found one on the ACLU website, and I really like this one. So the first page, so this is an example, right? You could use a different one if you want. Texas was actually the first state to develop or to pass laws about supported decision-making. And so they really have, if you look on their website, they have a lot of information about supported decision-making. But anyways, so the decider puts in their name at the top, that top line on the left. And then, the people who are going to help me are called my supporters. And then the decider puts all their information at the bottom. So this is supposed to be in plain English. So somebody who even, does not have like high school reading level can still understand. And then you have a page for each supporter. So you say the supporter, right? So that, maybe that would be my dad, or that would be, that could be the person's caseworker, or their uncle or their friend, right? They put in their name and how to reach them. And then they say, okay, these are the decisions that I want help making. So they can just check the box. So they read this over. You help them to kind of understand, who do you want to help you with learning to drive? Who do you want to help you about, choosing when you go to the doctor or the dentist? About, helping you turn the stove off, which by the way, I have some family members who are neurotypical who still have problems with that. So, so we're all on a range here. We all need supporters in our lives. But what about liability? I gave one presentation to the Ventura County Bar Association about supported decision-making, and all the questions were about liability. Because as lawyers, we're taught to look at who can be sued. It's kind of a paranoid way to live, but that's what we do. So there should be no liability for supporters. So if a supporter, suggests something, and then the decider goes and does that, or the decider goes and does something else, it's the decider who has the liability for doing that. So that's kind of the drawback of supported decision-making, is the decider does have liability, just like they're living in the community. So, you are taking a chance. And that's why I found that some parents just don't like this approach, because they're really, really afraid that their child will make the wrong decision. Now, I know a lot of parents of, neurotypical kids who are turning 18, 20, 21, their kids are not making great decisions either. So that does happen, in the community, but even more when your child may not understand the consequences of all their actions. And the supporter signs the document agreeing to act as a supporter. So they understand their role. And they buy into this. So that's really important, that the decider and the supporter have both agreed, this is where I want help, and this is where I'm going to provide help. Okay, so a few, some frequently asked questions. So who can be a supporter? Kind of anybody. Usually it's somebody in the child's life that the child really trusts, okay? What can supported decision-making cover? It's mostly, if you think of conservatorship with a person, it's mostly those things, where you live, your education, your activities of daily life, but it can also be helping me manage money, helping me decide, I think, every high school, and Alyssa actually and I were talking about this, every high school should have, how to budget class, right? So you can have somebody listed who helps your child with their budget. How is it formalized? It's with a, a written agreement. There's some great benefits. Now, I do want to mention, you can do supported decision-making even if you have a conservatorship. Your child can be conserved, but they can still learn these different skills within the protection of conservatorship. So this is not one or the other. It can be both. But if they're conserved, then they can't sign that contract and have it be valid. So there's limitations, but they can get a supporter to help them to learn how to budget, to help them to learn all the different skills of life. Okay. Supported decision-making can be used even for our kiddos who are nonverbal. Maybe they're communicating with a light writer or through sign language or something else. That's fine. How do you start this? So you don't hire an attorney for this. you can go onto a website that talks through these things. You can watch some videos. I know a woman named Suzanne Francisco has been key in really as an advocate for supported decision making. She has a lot of materials out there. But yeah, it's not really something you need an attorney for. And is it legally recognized? It depends on the state. Now, California, it's recognized. I actually have I didn't include it, but there's a map of all 50 states, and it shows about a third of the states right now have supported decision making, and some states only have it for like organ donations. It's very strange. Those tend to be the more red states, I have to say. No offense, but yeah, it's in a third to a half of the states. Okay, so let me just go through the last couple slides and then we can circle around for questions because I just wanted to talk about the other alternatives. We have, oh, wait, let me just go back to this. If you guys saw the show on Netflix, Down for Love, that's what this picture is from. I love that show. Please watch it if you haven't seen it. It's just so beautiful. It's like a documentary of basically matchmaking for kids with Down syndrome. It's just, and other developmental disabilities. It's so beautiful. Okay, so durable power of attorney. By the way, if you are age 18 and you have any form of capacity, you need, or 18 and up, you need a durable power of attorney. If you're on this call, you need a durable power of attorney. Why? Because what if something happens to you and you're incapacitated, you're alive, but you're in a coma, or you just are unconscious, you're out of it. You need somebody else to go pay your bills, talk to the utility companies, access your bank accounts, right? So please go sign a durable power of attorney right after this. You can get a statutory form online if you'd like, or if you're planning on updating your estate plan or starting it, you can, your estate planning attorney can help you prepare one as well. But in the context of your child signing a durable power of attorney, they do need to have capacity. Now that capacity doesn't have to be huge. Like they don't have to, be able to name all 50 states and, do trigonometry, right? But basically they need to acknowledge like, hey, I might have a savings account and here are my parents and I trust them to manage my finances and I don't have any concerns over it. Like that's kind of the level of capacity that they would need, okay? Now, durable powers of attorney are imperfect, all right? Some banks don't want to accept them. They might have their own form that they require your kid to fill out. It's awful. Banks should be accepting them, but some don't. Also, you're still imposing your decisions for your child. Even though it's voluntary, your child is not making the decisions necessarily, you are, all right? But it can be very helpful because you can still attend an IEP, you show them the durable power of attorney. Or the school where your child is, they might have their own form that they have the child fill out and sign. You can access their bank account. So it can be helpful even though it's not perfect. So then the other document that everybody needs on this call is an advanced healthcare directive, okay? So if you have somebody who's unconscious and they're in the hospital, what decisions do they want made regarding their body and who do they want to advocate for them at the hospital? Who should talk to the doctors, access their medical records, that sort of thing, okay? You can also have a healthcare directive where it's effective immediately. And sometimes that's really good for kids with developmental disabilities. So the parent can attend the doctor check-in or sign on the child's behalf for entering into a surgery or that sort of thing. Now, usually in a healthcare directive, you should do one if you're 18 or older, right? At some places like at Kaiser, they'd always ask me like, do you have your advanced healthcare directive? So maybe you've heard of this before or you've been bugged before, but you'd say, if you were in a coma, do you want to be maintained with life supporting treatment or should they let you go? So that's like one of the questions that they cover. Are you okay with organ donations? Do you have that little pink dot on your driver's license? Do you have a preference regarding disposition of remains? So all of these things are talked about on the healthcare directive. If your child doesn't understand these concepts, you don't have to fill that in. You can just kind of cross that out or just not answer it. But at least naming you to access their medical records and talk to the doctors. I think that's the most important part. Now, the child can revoke it. The child can say, I know I signed that, but you know what? I changed my mind. I don't want my mom making this decision for me. I want to make my own decision. So that's one of the main drawbacks of a healthcare directive is the child can always take it back. They don't have to follow it just because they signed it. It's voluntary. Okay, so that's all the information that I had. Just a little bit, you've seen this slide before if you came before. This is my firm. There's 13 of us, 3 attorneys and 10 support staff. We do serve all over California. We're online, so we're happy to help people in San Diego and other places. But again, we don't go to court anymore. So we don't do conservatorships. And we don't do public benefits applications or appeals. And then finally, if you want this set of slides, please take a picture for the QR code. And as before, if you decide to move forward with us, because we're always happy to help, we will make a donation to Parents Helping Parents. Oh, and if you like social media, we're on Facebook and LinkedIn, and we just started an Instagram page. And I have a YouTube channel that has 130 videos now, and I have like over 8,000 subscribers. I'm even making some money off of it. It's crazy. They're sharing the ad money. I know that's a new thing. So that's not why I started this, but I do have some videos on limited conservatorships and supported decision making. So you can look that up as well. Okay, so let's open this up to some questions.
Okay, what breaks on for a minute. First, I have to say Ellen has a video for everything, so I will get that YouTube link and put that in the chat for you as well. But I also would like to draw your attention to those pesky little evaluations that I just dropped, both the Spanish and the English, into the chat. I will be watching as we go along with the Q&A, and I like to get at least 75 to 80% participation the night of, because believe me, I wouldn't be doing this. I don't do this because it's fun. I do it because if we get positive evaluations, which I think we will for this presentation, that allows us to continue to bring this kind of quality programming to you. So please take a minute. 4 very simple questions. Probably 50 people could have done it in the time that I'm talking. Okay? All right.
So, if we were like on Dancing with the Stars, didn't they used to do, vote number 5, if you have 5, right? So give me good stars.
So, we have quite a few questions, but let me just say that a lot of them seem to be coming in saying, I haven't done it until my kid was 18. What do I do? So a little confusion around that, and that'll kick off about 8 questions. And then I'm going to turn it back over to Moira. She's doing a great job. Thanks, Moira.
So yes, just to reiterate what Alyssa said, what if your child is already 18? Oh no, you missed the window.
No, there's no window. A lot of people, they'll say, does my child need a conservatorship? And I say, not necessarily. Try it out without a conservatorship. See if the durable power of attorney and the advanced healthcare directive accomplish everything that you need. And then if you get stuck, if there's some situation after they turn 18, you can always apply. Or some people just don't know about a conservatorship and their kid is older and they say, wow, I didn't know about this option. Let's do it. It can be 18 and up.
Thank you. We're kind of in the speed round here. What does it mean? So there was a couple questions about like enforceability or being legally recognized, specifically talking about supported decision making. Can you clear that up?
It's not legally enforceable. This is a voluntary thing. I mean, it is a signed agreement, but like, what if the supporter decides, you know what, I don't want to do that? There's no legal consequences for that. This is really memorializing a relationship and letting people know this is what's expected and this is what we're hoping for. And then it's really on the people themselves to carry out those terms.
Really quick, Alyssa, we're getting feedback in the Q&A that the Google Forms are not letting people fill them out. They need access to the document, which is going to mean that we need to remind people to go back and try again as soon as Alyssa pops on and says it's good. So I'm going to pause for
audio.
1
Yes,
second.
that is a problem. I'm aware of it. I'm trying to fix it. I'm
Okay.
so glad that Moira is here. Thank you,
Okay.
Moira.
I will continue doing this, and I appreciate
Speed
Ellen's
round.
patience.
Okay.
Yeah, the speed round, so to speak. So there was a specific question really looking at limited guardianship and continuing to manage your child's social security income at the same time. I believe I'm translating that from Spanish correctly.
Yes.
Go ahead.
Okay, so if your child is receiving an income stream, it's still the representative payee, I believe, who manages that. You don't have to get a conservatorship over the estate if somebody has an income stream, but that's all they have, or they have $2,000 in their bank account. You really only need a conservatorship over the estate if they have like a chunk of money, or maybe they were, working for a bit and then they became disabled, or, something like that happened. So they kind of peacefully coexist.
Thank you. Question, moving. What if you get a conservatorship in California, move out of state, come back? Like, how does that work? And my hands are flying. Go.
Yeah, you have to reapply.
Like,
Yeah, I have somebody who is in Virginia and moved to California. And basically what we had to do is we had to apply for the conservatorship in California, but put a little note saying that they're still conserved, under guardianship in Virginia. And so we got a court order establishing the conservatorship pursuant to the termination of the conservatorship in Virginia. The problem is every state does it differently. And so California really refuses to rely on the rules of other states. Other states may not go through that process of vetting the parents. California has their own way. Now, if you move between counties, they may want to move the conservatorship to the new county because the court investigator might want to go visit your kid. And if you move from, San Francisco to LA, the court investigator is not going to be driving all the way down. They want it to be local. So you don't have to reapply or anything, but you do have to inform them that your child is moved, and then typically they would move the county in which the conservatorship is held.
This just in, alert the media.
Okay.
Please. I'm going to put on my Alyssa voice and my aura and say, please go now. Try those evaluation links again. Alyssa and Parents Helping Parents cannot bring you these high quality, topical and clearly in demand. We had 128 people on this call without getting some feedback for the folks that award grants, which is, I think, how most of us are funded.
That's right. That's right. And it is fixed. So thanks for the patience. Oh, my internet went out. It is fixed. So
awesome.
Good.
A couple questions really fast. This is a yes or no. Is a court hearing required to modify or terminate a conservatorship?
Ooh, I think they just changed the rule and they will, well, so I believe they set a hearing date, but I don't think you have to appear. It used to be that you had to appear. They're trying to make it easier to terminate a conservatorship. So now I don't think attending a hearing is required, which is awesome.
But to modify?
To modify, most likely you do.
It's not just change it on the form now. Go to court.
That's a good question. I don't think so, but I'm 90% sure. I'd have to go back and double check.
Thanks. That's good enough. 90% is good.
Yeah.
If a conservatorship was granted, but the letter wasn't supplied yet because of that delay, how do you resolve a situation, they're saying financial, that are impacted?
That's one reason why I stopped doing conservatorships. Santa Clara County is so behind the 8 ball. They're so short-staffed. So what I would suggest is go down to the county and stand in line and ask for that, at the probate court, and see if you can just pick up the letter of conservatorship. Because I don't know any other way to. It's not like at the DMV where they mail you that, but then they give you a little printout to use for 3 weeks. There's no printout. It really is problematic.
Yeah.
Yeah.
The fun-filled question of what happens to a limited conservatorship when the conservator passes.
When the conservator passes.
Yes.
Okay.
happens to that conservatorship when the conservator dies. Sorry.
Mhm.
And then there's an extra special question if I become incapacitated, but I'm still alive.
Right. So really somebody else will need to step up. So hopefully there's another family member in their life who can step up and apply as temporary conservator. And that can be granted in a short time, just like 1 week. And then they can apply to be conservator. If nobody steps up, then most likely you have the public guardian standing in. So it's really good to get a succession plan in place. You can also put in your estate plan, in your will, or in a separate document, you can nominate the successor conservator. And so at least the court will know what your wishes are. If you're gone, they'll say, hey, this was this person's choice. We're assuming that that was the best choice, even though we still will go through that vetting process.
Melissa, did you want to make another announcement?
You bet I did. The responses are coming in, but I'm not quite close to my 75%. So please, sorry for the mishap, but please engage those links for simple questions for simple answers. And keep them all in the yes, agree, totally agree category.
We're looking for at least 93 people to fill out.
There you
all
go.
right.
Help them get those
Keep
grants.
going. I feel like
Please.
I'm on a game show or something.
This one's a little more complicated. Someone has twins on this call. One is regional center, one is not. Both are very collaborative and can make decisions, but due to executive functioning, they cannot follow through on those decisions. And so, it just moved on me. The question is, what would you do to support them?
Wow. Well, first, see, do you really need a conservatorship? Right? So and I have a video called Does My Child Need a Conservatorship? And I kind of go through the different scenarios you may not. If they have executive functioning issues, supported decision making might be a better option. Otherwise, if you have one child, even if they're a twin, only the child who has regional center services will qualify. You can't just argue, hey, they share genetic material, and so the other one should be able. No, you need that regional center membership.
What happens to I'm sorry, how many family members must we notify of conservatorship? And must they be from both paternal and maternal families?
So you need to notify the grandparents if there's any grandparents, and you need to notify the siblings. So that's kind of the second degree, and the other parent, if there's another parent. You don't have to notify cousins or aunts or uncles or nieces or nephews.
A couple was just added as conservatorships for a family member. Are you familiar with issues of conservators not being able to act independently? So the example is I tried to open a bank account and the bank said they would not open the account if there were multiple conservators listed in the letters.
Well, so
yeah, there are a couple of questions about, I'm sorry, there are a couple of questions about how many do the co-conservators need to sign, like all the co-conservators need to sign things, so maybe just address that issue.
Right. So it depends on what it says in the letters. If you have, A person or B person, then one needs to sign. If you have A person and B person, both need to sign. So make sure that, and when you're working with an attorney, they'll draft the letters of conservatorship to submit to the court. The court doesn't come up with their own, okay? Or you, if you're doing, pro se, if you're representing yourself, you would be required to submit them. So just make sure to put an or, and that should be okay.
How early can we apply?
The hearing date, the earliest, is basically the week of that person's 18th birthday. So you can prepare a year beforehand, but the capacity declaration is only valid for, I think, like 6 months. Is that right? So don't get, or maybe 3 months. So don't start too early.
We thank Ellen certainly for her time these past 4 sessions. We are so grateful that you gave your time and your energy and your knowledge to us. Thank you, Moira, for coming on and expertly facilitating those questions, especially since I had technical issues tonight. Thank you, Beatrice. I know we talk really fast and I know you do a great job.